Hello and welcome to this, our sixth and final seminar in the Davis Blank Furnace series, Commercial Lease Termination and Renewals under the Landlord and Tenant Act 1954. The series has been designed for surveyors, property agents, in-house lawyers and landlords and tenants themselves to assist them in navigating the often complex world of commercial landlord and tenant matters. My name is Sean Hackett and I am a partner and the head of the Davis Blank Furnace Property Litigation Department. And over the past 5 seminars, we've built a comprehensive understanding of the Landlord and Tenant Act 1954. We started by exploring the statutory protection and contracting out, moved through termination processes and opposed renewals, examining both fault and non-fault grounds, and most recently explored unopposed renewals, including rent determination and the OMA principles for other lease terms. Today we're addressing 4 specialist topics that frequently arise in lease renewals but deserve detailed examination. Interim rent under sections 24A to 24D of the Act, guarantee provisions in renewal leases, alterations and reinstatement, and standards of repair. These are all practical real-world issues, and understanding how the Act and the court deals with them is essential for comprehensive advice to clients navigating lease renewals. Today's session is structured around 4 distinct topics, each of which addresses common pitfalls, which are either overlooked in whole or in part. The first relates to interim rent. So when a tenancy is holding over after the contractual term expires, what rent should the tenant pay? Should they continue paying the old rent, or should they pay an interim rent reflecting the current market levels? And how is interim rent determined, and when should the parties apply for it? The second relates to guarantee provisions. If the original lease contained a guarantee from a parent company or a director, should the new lease contain equivalent provisions? What happens if the original guarantor is no longer appropriate or available? Can the landlord insist on guarantees in renewal leases? Third, and the fourth relate to alterations and reinstatement, which have already been undertaken. What, if anything, does the landlord or tenant need to do about these alterations and the requirements to reinstate? And then finally, the topic of standard of repair. These topics may seem technical, but they have significant commercial implications for both landlords and tenants. Let's begin with the topic of interim rent, which is governed by sections 24A to 24D of the Act. These provisions were substantially reformed by the Regulatory Reform Order of 2003, which came into force on the 1st of June 2004. To understand interim rent, we must first recall what happens during the holding over period. As we discussed in Seminar 2, when a qualifying business tenancy reaches the end of its contractual term, it doesn't simply terminate. Instead, Section 24 of the Act provides that the tenancy continues automatically on exactly the same terms until it is determined in accordance with the Act. This creates a potential problem. The rent specified in the original lease may have been agreed years ago and may now be significantly below or occasionally above current market levels. Should the tenant continue paying this outdated rent during the holding over period? The answer is that either party can apply to the court for an interim rent determination. This allows the rent to be adjusted to reflect current market conditions during the continuation period. The purpose of interim rent is to ensure fairness between landlords and tenants during the holding over period. Without interim rent provisions, landlords would be stuck receiving below market rents whilst negotiations or proceedings continued. And conversely, tenants paying above market rent would continue to overpay. The interim rent provisions strike a balance. They allow rent to be adjusted, but with certain protections and limitations that recognise the temporary nature of the situation. Section 24A(1) provides that either the landlord or the tenant may apply to the court for interim rent determination where the landlord has served a Section 25 notice or the tenant has served a Section 26 request. The application can be made by either party, giving both the landlord and the tenant initiative. However, there are important timing restrictions. Section 24A, subsection 2 provides that if one party has made an interim rent application, the other party cannot make a separate application unless the first application is withdrawn. More significantly, Section 24A, subsection 3 provides that no application can be made more than 6 months after the termination of the relevant tenancy. This is a strict time limit, so if you miss it, you've lost your right to apply for interim rent. The interim rent runs from what Section 24B calls the appropriate date. This is defined as the earliest date that could have been specified in the Section 25 notice or the Section 26 request. In practice, this means that the interim rent typically runs from the date specified in the notice or request as the termination or commencement date, not from the date the notice was served. Now, the timing is crucial. If the market rent has increased since the original lease was granted, a landlord has a strong commercial incentive to serve a Section 25 notice as early as possible, up to 12 months before the contractual term expires, so that the interim rent will run from the earliest possible date. Conversely, if the market rent has decreased, a tenant has incentive to serve a Section 26 request early for the same reasons. The Act now provides two different approaches to determining interim rent, depending on whether a new tenancy is actually granted. Section 24C applies where the landlord does not oppose the renewal and a new tenancy is granted, where Section 24D applies where the landlord opposes renewal or where Section 24C doesn't apply for other reasons. So let's now examine each of those in turn. Section 24C subsection 1 establishes the basic rule where a new tenancy is granted. The rent under the new tenancy is also the interim rent, and that makes perfect sense if the parties have agreed or the court has determined that the new rent should be £50,000 per annum. That same figure should apply retrospectively as the interim rent. However, Section 24C subsection 2 and 3 provide two important exceptions to that rule. The first exception applies where either party satisfies the court that the interim rent would differ substantially from what's called the relevant date, that is the rent the court would determine under Section 34 for a new tenancy commencing on the appropriate date. And the second exception applies where either party satisfies the court that the terms of the new tenancy differ from the terms of the existing tenancy to such an extent that the interim rent under the basic rule would be substantially different from the Section 34 rent. Now, these exceptions recognise that sometimes the rent for the new tenancy doesn't fairly reflect what the interim rent should have been. Section 24D applies where Section 24C doesn't apply, and is most commonly used where the landlord successfully opposes a renewal and no new tenancy is granted. Section 24D subsection 1 provides that the interim rent is the rent which it is reasonable for the tenant to pay whilst the tenancy continues under Section 24. Section 24D subsection 2 directs the court to have regard to the rent payable under the existing tenancy and any subtenancies, but otherwise to apply Section 4 principles as if a year-to-year tenancy of the whole property was being granted. Now, this approach generally results in an interim rent that's slightly lower than full market rent for a new term certain, reflecting the temporary and uncertain nature of the holding over period. The decision whether and when to apply for interim rent requires careful strategic considerations. And for landlords where the market rent exceeds the passing rent, applying for interim rent as soon as permissible makes commercial sense. Every month of delay means losing rental income. However, landlords should remember that once proceedings are issued, both parties incur costs, and if renewal negotiations are progressing well, it may be prudent to wait for an agreement rather than incurring legal costs for what might be a modest uplift. And for tenants where market rent is below the passing rent, applying for interim rent can result in a rebate. And this is particularly valuable where overpayments are substantial. But tenants should be cautious. Applying for interim rent when you're paying below market rent could backfire spectacularly if you've miscalculated the market conditions. The 6-month deadline in section 24A subsection 3 is crucial and it's unforgiving. If you fail to apply within 6 months of the tenancy's termination, you've lost your right permanently. This creates particular risks where opposed renewals proceed to trial. If the trial is lengthy and appeal follows, the 6-month deadline could pass before the tenant even knows whether they're getting a new lease. In such cases, landlords commonly apply for interim rent as a protective measure, even if the outcome of opposition remains uncertain. I now turn to a series of questions. What happens to the guarantees given and the requirement for an AGA on a lease renewal? Many landlords require tenants to provide a guarantor before granting them a lease of a commercial premises in the first instance, and the majority of those same leases also require the tenant to enter into an authorised guarantee agreement, an AGA, with the landlord as a condition of the assignment of the lease to a new tenant pursuant to section 19(1)A of the Landlord and Tenant Act 1927. So question, what happens to the guarantees given in the original lease and the requirement to give an AGA on a lease renewal? And what happens to the guarantor's liability when the fixed term of the lease ends? Well, it depends on the terms of the guarantee, and the first port of call is to consider what the current lease, which is coming to an end, states in terms of the guarantee provisions. Junction Estates versus Cope, a 1974 case, made it clear that the liability of a guarantor under a lease will not extend beyond the contractual fixed term into any statutory continuation unless the express terms of the guarantee provide otherwise. So whilst the tenancy continues beyond the contractual fixed term by virtue of the statutory continuation under section 24 of the Landlord and Tenant Act 1954, in the absence of express words to the contrary, the guarantee will not. So the next question is, what happens to the guarantor's liability when the tenant enters into the new lease? If the wording of the guarantee is such that the guarantor is liable for the contractual fixed term and any period of holding over under statutory continuation, then the guarantor's liability will continue until the tenancy is brought to an end. A new lease has the effect of bringing the original tenancy to an end and creating a new tenancy which is governed by the terms of the new lease. If the guarantor does not enter into a new guarantee in respect of the new tenancy, then its liability will come to an end when the original tenancy ends. So the next question is the landlord entitled to insist upon the guarantor entering into a new guarantee when it grants the tenant a new lease? The answer is yes and no. Under section 41A subsection 6 of the Landlord and Tenant Act 1954, where the court is ordering a new lease where A, the tenants were in partnership, and B, only one of two or more joint tenants are taking the new lease, then the court has the power to order that a renewal lease includes a provision for guarantors. Otherwise than in that scenario, the court is not entitled to refuse the grant of a new lease where the tenant is not willing to provide a guarantor. However, the court can order the new lease to contain a provision that the tenant secures a satisfactory guarantor to join the lease within a specific period, and a failure to do so will give rise to a breach of the lease and entitle the landlord to serve a notice under section 146 of the Law of Property Act 1925 before moving to forfeit the lease if the breach is not remedied. The next question is Is the landlord entitled to insist upon a term in the new lease that the tenant enters into an AGA with the landlord as a condition of assignment? Well, the starting point is to establish whether the new lease contains a covenant against alienation. If there's an absolute prohibition, i.e. an outright covenant against alienation, then the requirement for an AGA makes no sense. If there is a fully qualified covenant against alienation, i.e. a covenant against alienation which says that the landlord's consent will either be expressed to not be unreasonably withheld, or in the absence of the wording that I've just mentioned, not to be unreasonably withheld, are added to the covenant by virtue of section 19(1)(a) of the Landlord and Tenant Act 1927, then it is possible that an AGA may be required if reasonable. It's not the case that the landlord is automatically entitled to an AGA on a lease renewal as of right. The condition in the new lease that the AGA is to be given on assignment must be reasonable. In the case of Wallace Fashion Group Limited versus CGU Life Assurance Limited of 2000, the court held that where it is called upon to determine the terms of the new lease under its powers set down by section 35 subsection 1 of the Landlord and Tenant Act 1954, section 35 subsection 2 expressly requires it to have regard to the Landlord and Tenant Covenants Act of 1995 and section 16 subsection 3b of the Landlord and Tenant Covenants Act 1995 provides that a landlord's requirement for an AGA is only valid and enforceable if the requirement for the AGA was lawfully imposed. In that case, Judge Nuremberg said that the landlord, if it is reasonable to demand an AGA as a condition of his consent to assign, then that demand for an AGA is lawfully imposed. If it is unreasonable to make such a demand, then it is not lawfully imposed. Now, the effect of the above is that if there is a fully qualified covenant against alienation, i.e. no assignment without landlord's consent, such consent not to be unreasonably withheld, then the new lease should expressly record a phrase such as "were reasonable" before the requirement to provide an AGA as a condition of consent. It should be clear in the new lease the requirement for the "were reasonable" AGA is not a condition agreed pursuant to section 19(1)(a) of the Landlord and Tenant Act 1927. So when it comes to lease renewals under the Landlord and Tenant Act 1954, everybody focuses on the headline issues: rent, term length, break clauses. But there are areas that are often overlooked and will not become apparent until it's too late with serious consequences. And we're talking about tenants' fixtures, reinstatement obligations, and the standard of repair, for example. So let's start with fixtures, because this is where I've seen the most expensive mistakes being made. And under the old common law, anything fixed to the land became part of it. It was stated that what is affixed to the soil becomes part of it. That meant tenants who installed items lost them to the freehold when their lease ended. So if a tenant installed a heating system, being a tenant's fixture, and had not removed it before vacating the premises at term end, it became a landlord's fixture, and the tenant had to yield up the fixture in accordance with the repair obligations under the lease. Under the 1954 Act, when a business lease is renewed, either by agreement or court order, the new lease effectively starts afresh. So what happens to those fixtures that the tenant has installed during the old term? Do those fixtures stay as the tenants, or have they become landlord's fixtures? In the case of New Zealand Government Property Corporation versus HM&S Limited in 1982, Lord Denning took the view that a tenant shouldn't lose the right to remove fixtures simply because they take a new lease. He said, and I'm quoting, "In my opinion, the tenant remains entitled to remove the tenant's fixtures so long as he remains in possession." He went on to say, "I hold that when an existing lease expires or is surrendered and is followed immediately by another to the same tenant remaining in possession, the tenant does not lose his right to remove tenant's fixtures. he's entitled to remove them at the end of his new tenancy. Therefore, where a lease expires or is surrendered and is followed immediately by another to the same tenant who's remaining in possession, the tenant doesn't lose the right to remove the tenant's fixtures. But, and this is crucial, Lord Denning noted that it all depends on how the demise premises are defined in the new lease. If the new lease defined it as being the premises together with all fixtures and fittings therein, that will result in what was the tenant's fixtures and fittings now becoming landlord's fixtures and fittings. The practical point for advisors is to review the definition of the demise premises in the new lease. It should expressly exclude tenant's fixtures and fittings, or better still, include a schedule listing what the tenant has a right to remove. The danger is to assume that the position under the old lease will continue. Now, the related question is, even if the tenant keeps the right to remove the fixtures, can the landlord charge rent on them in the new lease? And the answer is potentially yes. And this is where Section 34 of the 1954 Act becomes important. Under Section 34 of the Act, the court determines the new rent based upon the rent at which the holding might reasonably be expected to be let in the open market. But as discussed in Webinar 5, there are statutory disregards, and under Section 34, subsection 1c, the effect on rent which the tenant improvements may have on rent are to be disregarded. So if the tenant has decided voluntarily to install air conditioning, which is a tenant's fixture, which will be an improvement, that is disregarded when looking at the new rent. However, if the tenant was under an obligation to the landlord to install the air conditioning as opposed to the tenant volunteering to install it, then the disregard under Section 34, subsection 1c does not apply, and the air conditioning can be monetized in relation to the new rent. And if the fixture becomes part of the demise premises under the new lease definition, because it defines it as the premises together with all fixtures and fittings therein, then the air conditioning is no longer a tenant fixture, but is part of the premises, and the air conditioning can again be monetized in relation to the new rent. The key point is that fixtures and improvements need to be clearly identified and documented with express provisions that they're disregarded for rent review and renewal purposes, and that the new lease does not seek to incorporate tenant fixtures into the definition of the demise premises. Now, chattels are different, but I'll cover them for the sake of completeness. They are movable items not affixed to the property, like loose machinery, and they remain the tenant's property unless they're abandoned. And on the renewal, the landlord can't claim them, and they're not part of the demised premises. Moving now to look at reinstatement. And it's probably best that I give you an illustration. Let's say the tenant installs a mezzanine floor, all properly consented to and all documented in the license for alterations. Those licenses likely require reinstatement at lease expiry. But what happens to those reinstatement obligations when the old lease ends and the new lease is entered into as part of the lease renewal process? The short answer is that the obligations can be lost if they're not carried forward into the new lease. Think about it logically. The obligation to reinstate was in the original lease or in the license connected to that lease. And when the tenant took a new lease under the 54 Act, the obligations under the old lease did not continue. Unless the previous reinstatement obligations were expressly incorporated into the new lease, they simply don't survive. The solution is to address this head-on in the renewal negotiation. Review all licenses for alterations granted during the previous term and decide which reinstatement obligations should continue, and document that in the new lease. Finally, let's talk about repair standards, because this is the one that catches many out and is perhaps better understood by way of illustration again. So say a tenant takes a brand new building on a 10-year full repairing lease in 2015. Pristine condition, everything works perfectly. The lease requires them to keep it in good repair and condition. The tenant then renews in 2025 for another 10 years, and when they hand back in 2035, what's the standard of repair? The instinctive answer would be that the condition is what it was back in 2015 when the original lease started. But unless the parties expressly provide otherwise, the standard of repair under the renewal lease is anchored to the date of the renewal lease, not the date of the original grant. In our example, that is going to be 2025 and not 2015. You can see that for landlords, this is a disaster. They've lost 10 years of deterioration, and for tenants, it's a windfall. They've effectively got a step down in their standard of repair obligation. The solution is simple, but it requires active attention. In the renewal lease, the landlord must specifically state that the tenant's covenant to keep the premises and good repairs shall be construed as requiring the tenant to maintain the premises to the standard of repair existing at the date of the original lease. And if there's a schedule of condition or photographic schedule prepared at the start of the original lease, the tenant will want to ensure that they incorporate the reference to that in the renewal lease, else they will lose the benefit of that qualification to their repair obligations. This brings us to the end of our 6th and final seminar in this series on commercial lease termination and renewals under the Landlord and Tenant Act 1954. Over these 6 seminars, we've covered the statutory protection framework, contracting out procedures, termination mechanisms, fault and non-fault grounds of opposition, unopposed renewal proceedings, including rent determination and lease terms, and today's specialist topics of interim rent, guarantees, reinstatement, alterations, and standards of repair. The Act's now over 70 years old, yet it remains fundamental to commercial landlord and tenant relationships in England and Wales. And the Law Commission has recently reviewed the Act, and changes may come, but the core principles that we've discussed will endure, balancing the landlord's property rights with the tenant's business security, providing clear procedural frameworks and ensuring fairness between the parties. And for those of you advising clients, whether landlords seeking to manage their property assets effectively, or tenants wanting to protect their business locations, or professional advisors guiding clients through these processes, I hope that these seminars have provided valuable insights and practical understanding. Of course, should you require assistance with any aspects of commercial lease renewals or disputes under the Act, or any of the topics that we have covered in this series, our commercial property team and the property litigation team here at Davis Blank Furnace are equipped to support your commercial objectives. Please do contact us for tailored advice specific to your circumstances. Recordings of all 6 seminars and copies of our slides are available on our website. All that remains is for me to thank you for joining us on the series, and we look forward to welcoming you on the next series.